Thank you. It is especially important for this group to be aware of how to conduct yourself in any legal problem because the medical monopoly and the drug trust claim that you can only commit one crime in medical practice in this country, and that crime is if you cure somebody. Now, the money is in treatment. The money is not in cure. Once a doctor cures you, his money stops. And it's the same thing in the legal practice. When a lawyer successfully ends a case, then his money stops. So this is why in our courts, the cases drag on for year after year, because as long as the cases drag on, the money keeps coming in. And this is one reason that the Wall Street Journal on the editorial page said recently, the interests of the lawyer are not necessarily congruent with those of the client. Now, they could have made it plainer. They could have said the interests of the lawyer are never congruent with the interests of the client, because that's usually the case. Now, there are some very gloomy statements about our present legal system. Jerry Spence, who is a $1 million a year lawyer, recently published a book called Justice for None, in which he states plainly, there is no justice anywhere in any court for the American people. This was his experience as a lawyer. Well, I say the justice is there, but you have to dig for it, you have to claw for it, you have to fight for it, but it is there if you go after it. Now, Judge Learned Hand, who was a very distinguished jurist, he was so distinguished that he could never be nominated to the Supreme Court because only political hacks are allowed to be nominated to the Supreme Court. So Judge Learned Hand never made it. But he did state in an address to his fellow lawyers a few years ago, he said, short of sickness or death, I would dread a lawsuit above all else. Now, the reason Judge Learned Hand said this is, once you become entangled in the legal machinery, it's sort of like being in a spaceship drifting through space and you don't know how to control it, you don't know how to get out of it. You have to start thinking, how am I going to get out of this mess? Because once you get into the legal system, nobody can help you, and your lawyer is likely to help you least of all. Now, the reason lawyers don't help you is very few lawyers practice law. I discovered this quite by accident because when I began to file lawsuits, and I have to say that I have never been a defendant. In 40 years in courts, I have always been the plaintiff. So I don't know what it feels like to be a defendant, and I really understand that it's a very harrowing experience for someone to become a defendant in an American lawsuit, even though I have no practical experience of that myself. Because by being a plaintiff and by coming on the scene first, you more or less dictate the course of action. And you have to have a strategy. You have to know what you want to do. Now, I was talking to one of the richest men in America in Texas a few years ago, and he was deeply embroiled in a lawsuit, and he subsequently lost most of his fortune. So I said to him, he had gone through one lawyer after another, I said, well, just what is your legal strategy? Well, he was totally puzzled. He had no legal strategy. It's like going into a battle without knowing just what you're trying to do. But you can plan, you can decide what you want to do, because I found that the practice of law in this country is really quite simple. There are 3 precepts that you have to follow. First, you have to answer everything. Now, when you come into court and represent yourself, the lawyers and the judge consider you as fresh meat. They're going to tear you apart. So the first thing the opposing lawyer will do is file a set of written interrogatories against you, and he will ask you the most personal questions and the most questions which will make you very indignant, and you say, I am not going to answer this. This is illegal. It's unconstitutional. So I refuse to answer. Then you go back into court, and the opposing lawyer immediately asks for a default judgment against you because you have failed to answer the interrogatories. And the judge immediately grants that judgment, and you lost your case right there. So that's why I say answer everything. And the second precept is always deny everything. You can admit your name, but do not admit anything else, because anything else you admit or agree with, they're going to use against you. Now this, of course, is contrary to the American way. I mean, we are decent and sensible people, and if someone makes a charge of some kind that there is a little truth, we'll say, well, yes, I admit that there is a certain amount of fact to that, but the extenuating circumstances make it entirely different. Well, when you're in court, those other circumstances mean absolutely nothing. The fact that you have admitted even 1% of what they're charging you with, you immediately fall into their clutches and it's all over. So that's why I say answer everything, deny everything, and the third precept is answer on time. In the courts, they operate on very strict time sequences. Usually you have 21 days to answer something, a motion or a complaint and so forth. And you have to be extremely careful to stay within those time limits. Now, this is not true of lawyers themselves. The lawyers themselves are very sloppy. They frequently will forget to answer a motion within 21 days. And we go before the judge, and the lawyer says, well, Your Honor, he says, I was very busy, and my secretary didn't remind me of this. And so the judge said, that's all right, Paul. They always call the opposing attorneys by their first names, by the way. In my experience in courts, whenever the opposing lawyer stood up before the judge would smile and say, oh, yes, Paul. And when I stood up, he'd say, yes, Mr. Mullins. So you can see that you're always the enemy. You're always the alien. Well, that didn't bother me because I've always been an outsider anyway. But, and as George Gordon always says, if you're in court and you're not having fun, you shouldn't be there. So I've had a lot of fun in court, but my great fun was in swamping the opposition with motions, and I love doing research, and so of course when I went to the law library, I just found tons of material that I wanted to bring before the court, and these lawyers were absolutely stunned because the average motion filed against me is about one paragraph. I usually filed 9, 10, 15-page motions, and because Latin is the traditional language of the law, I sprinkled my motions with whole paragraphs in Latin. Well, this made the opposing lawyers furious, because even though Latin is the language of the law, none of these lawyers, of course, could read any Latin. And actually, I had a couple of decisions against me from the judge. The lawyers got the judge to issue an order that I could no longer use foreign languages in my motions. So when you can, well, I didn't just use Latin. I would sometimes copy a paragraph in Spanish or German. See, I use the Oxford English Dictionary a lot, the OED. And the OED are enormous volumes, and whenever they define a word, they'll give about 2 pages of citations going back to the year 1 AD, and a lot of them will be in foreign languages. So I would copy these down and present them in my motions, and of course, everybody was totally mystified. In fact, a lot of them I wasn't able to translate myself. But I was never embarrassed about that, because when we deliberated on these motions, they never dared ask me what this meant, because that would be admitting they didn't know what it meant. So, as I say, I was never embarrassed by that. But I wrote The Rape of Justice because after some years in the courts, I realized that I had certain advantages which the average American citizen does not have. That is the ability to do this writing and research. Because our legal system is nothing but words and paper. And of course, some of the words are outrageous and a lot of the papers are outrageous, but they get away with it because that is the system. So what you've got to do when you go into court, give them all the words and all the paper that they can handle, and then you get on top of the situation because they begin to struggle to keep up with you. You're not struggling to keep up with them. I would be filing these long motions and they would be arguing them. And the motions are argued in the judge's chambers. I very seldom got into court because the mission of every lawyer who opposed me was to keep me from ever getting into court, which they usually did. But I would keep them in the judge's chambers month after month for 2 or 3 years. And generally, you file a precipice to have a motion heard in chambers, and you state on there what your motion is. And I invented all sorts of new motions which no one had ever heard of. Motion for more equitable procedure, and I had lots of them. And so you'd put down the time that you were going to allow for hearing this motion, say 5 minutes or 10 minutes or 15 minutes. So when we'd go in to argue these motions before the judge, I would usually put 15 minutes. But then, because the lawyers couldn't handle these motions, we would sometimes sit in there for an hour and a half arguing back and forth. And meanwhile, because only 15 minutes had been allowed, there would be 8 or 10 high-priced lawyers waiting in the anteroom with their motions. And finally, I would come out and I would see all of these beautifully dressed lawyers in their $1,000 suits who had been sitting there for an hour waiting for me to get through. So all of this made me feel sort of good. But my greatest sport of all, which I got into quite accidentally, because whenever you become involved in any legal procedure in the United States, you will find that the opposing lawyer will commit the most outrageous and insulting attacks upon you that you can imagine. And they're usually illegal. So because of these attacks, I began to sue the lawyers. And this is, I don't think, had ever happened in my state before that anyone dared to sue a lawyer. Because a lady told me that she went up and down the entire state trying to find a lawyer who would sue a lawyer who had double-crossed her. Her multi-million-dollar husband, who had a billion-dollar business, had ditched her in favor of his mistress, and so of course she had a lawyer for the divorce proceedings, and her lawyer had sold her out so that she only wound up with $25,000. So she knew that she had to sue that lawyer. So she did. She traveled to almost every city in the state. She could not find any lawyer who would take a case against another lawyer. And in fact, there's only one lawyer in the United States who makes a practice of suing other lawyers, and that is Edward Friedberg of San Francisco. And he has won some very hefty judgments in the millions of dollars against his fellow lawyers in California, and he's caused the cost of malpractice insurance to become prohibitive in the state of California. But he's still the only one, and in the other states, when you go looking for a lawyer to sue a lawyer who has really damaged you, you are not going to find anybody. That is why you have to go in and represent yourself. Now, my feeling in going into court, and as I did many days, going in alone, it was sort of like going into a medieval torture chamber and wondering, now what instrument are they going to use on me today? Are they going to use the thumb screw? Are they going to use the red-hot pincers? You know, it was sort of exciting to think, what lay in store for you? Because I knew they would do anything to me that they could. And this is another protection you have. You always have to know that there is nothing that these people will not do. Because when you go into an American court, you are dealing with criminals. You are dealing with criminal lawyers. You're dealing with criminal judges. I don't think I ever appeared before a judge in the United States who should not have been serving time in prison. And I don't say that with any vindictiveness because I actually have won some decisions in American courts. I won because I wore them out. Because they tried everything in the book and it didn't work and they finally threw up their hands. And this is what you can do. Now, when I sued one lawyer, he promptly got it dismissed as insufficient cause of action, a demurrer. So I talked to a friend of mine in Washington that night, and he said, well, just go down and refile it. I said, well, they've dismissed it. He said, well, go refile it anyway. So I went down the next morning and I refiled it. It cost me another $5. So we appeared in chambers again, and this lawyer was one of the highest priced lawyers in the state, and he actually almost had tears in his voice. He said to the judge, he said, Mr. Mullins is persecuting me. So here I am, entirely alone, no money, no influence, no nothing, and yet I can bring these lawyers into court and give them such a hard time that they practically cry. And also, every lawyer whom I sued, his malpractice insurance would double. And I knew nothing about this. I was suing lawyers for several years. I had no idea about this beautiful little side effect, but Finally, one lawyer, I'd had a case against him for about 2 years because he had really pulled some outrageous stuff on me. And every suit that I filed against a lawyer, I got right out of the state statutes. I cited chapter and verse right down the line. And you never want to bring a frivolous lawsuit. You want to have absolute documentation for everything that you go into court with. And I never had any problem with that because I always had more documentation than I could handle. So this lawyer came up to me outside the judge's chambers one morning, and he looked sort of haggard, and he said, you know, Mr. Mullins, don't you know that for the past 2 years, my malpractice insurance has doubled? And of course, that was such a wonderful thing to hear. Because I say I had no idea about this, but he very freely gave me this encouragement, and so that made me more intent on suing lawyers than ever. Now, I did win one very important case because of this practice that I developed of suing lawyers. Now, we only have about 12 lawyers in my town, and I think over a period of about 6 years, I had sued 8 or 9 of them. So, I had a case on property in Chancery, which involved quite a lot of property. It involved just about everything I had. So I was allowed to choose the commissioner in Chancery, which is a substitute judge, who will act as a judge and render a decision, which will then be rendered to the judge for his signature and becomes effective when the judge signs it. So we had a man who had just retired from the Navy as a judge advocate, and retired lieutenant commander, and he had represented some citizens in a suit against the state, and I thought, well, this guy probably would be a pretty good guy, and so I named him as my commissioner of Chancery. What I didn't know at that time was that he was up to become the Grand Master of the Masonic Lodge in Virginia, and that he had no interest in helping me because the guy, the opposing party, was a Mason. So there was nowhere I could go with this suit, and I found that out the hard way. So we had our hearings, and very extensive hearings, and it was all taken down, and I had my witnesses, and the opposing party had their witnesses. So then this commissioner delivered his opinion, a written opinion about 5 pages long, single-spaced. And what he had done, he had totally ignored all of the testimony in favor of my cause and had totally accepted all of the testimony from the opposing party. So he ruled against me that everything that I had in my house had to be turned over to the opposing party. So I knew I was in a real dilemma. So I thought, this was delivered to me on a Friday afternoon. I knew on Monday the judge would sign the order and a truck would come up and take everything out of my house, all of my files and everything. So I very quickly filed a motion that same day, and this is another thing that you have an advantage in representing yourself, because I talked to the Commonwealth's attorney one day about motions in a case that we were talking about, and I said, how long do you all usually take to prepare and file a motion? He said, oh, usually about 6 weeks. Well, I was stunned because my time usually was about an hour and a half to prepare and file a motion. So anyway, they didn't think that I would be able to do anything about this unfavorable report from the Commissioner in Chancery. So I filed a motion about 5 pages long and went down and handed it to them the same day, in which I stated that the Commissioner in Chancery's decision was biased, was prejudiced, was contrary to the evidence, and contrary to the law. So the judge then had to postpone everything until the commissioner answered my objections. So we went before him again, and the judge said, well, the only thing I can do is have you hold more hearings under the same commissioner. Well, I wasn't going to stand for that, so I went back and I prepared a lawsuit against the Commissioner in Chancery for $350,000, charging him with bias and prejudice. So he then wrote a letter to the judge stating that because of Mr. Mullins' attitude, I feel that I should withdraw from further hearings. So then we went back to judge's chambers, and he said, now, Mr. Mullins, we'll have to choose another commissioner in Chancery. So he started reading off the list of the local lawyers, and he would read off a name. I'd say, well, Your Honor, I've sued him. I don't think he would be a good choice. So we got to the end of the list, and there was nobody that they could choose because I had sued all these lawyers, and not realizing at the time that I would get this later benefit from it. So there again, you should take all the actions that you can in law. Don't ever sit back and say, well, I feel like doing that, but I'm not going to do it. Go ahead and do it, because you'll get some benefit out of it later on that you're not anticipating. So then the judge said to me, well, Mr. Mullins, I think what we'll have to do, you'll have to go to another city to get a commissioner in Chancery. He said, I said, where should I go? He said, well, you can go to any city in the state. So in other words, I was to spend the next 2 years traveling around the state trying to find someone who would come to Stanton and be a commissioner in Chancery. So I just left it in limbo for about another year. And finally, I got a letter from the opposing attorney stating that they were willing to settle the case for any amount that I wanted. Any amount, small or large. So I thought of $1, and then I thought, well, that's kind of ridiculous, because there was a lot of property involved, which was quite valuable. And so I finally said, well, I'll settle it for $50. So I sent them a check for $50, and the whole case was over, and I had retained all of my property. I had removed a threat. Now, most people would have been wiped out by this, because the judge would have signed that order, and they would have come up and they would have taken everything out of their house. It happens all the time. So you have to counterattack any time. The day that you get anything from a lawyer, you have to counterattack on that very day. Don't wait and say, I'll do it tomorrow, I'll do it next week, because that's what the lawyers do, because they let it drag on because they have nothing to lose. But you're fighting for your life, and you have got to fight back, and you've got to fight back right away. Now, this is what happened when the Internal Revenue Service called me in for an audit. And the reason they called me in for an audit was one of the lawyers whom I had sued, and I was carrying on a case against his client, which I kept upping the ante. The man had run into my car, and he really had tried to kill me. And so he got out and said, well, my insurance will take care of it and so forth. Well, when I put the claim into his company, they said, well, he has informed us not to pay it. So, of course, I filed suit against him. And after this case, it dragged on for about 2 years. The opposing attorney decided that they had to get rid of me. So his solution, and this is very common, by the way, when you get involved in a lawsuit, the opposing attorney will quite often go over to a friend at the IRS and say, look, why don't you take care of this guy for us? So this is what this attorney did. He went over to the IRS and he said, why don't you call this guy in for an audit, because I'm sure you'll find a lot there that will get rid of him for us. So I was going by his office one day, and this man had already begun to die of cancer, just as Sigmund Freud did. It was cancer of the face. His whole face had begun to be eaten away. So I walked by him, and he said, "Oh, Mr. Mullins." I said, "Yes." He said, "Could I speak to you for a minute?" Well, you have to be very careful about talking to lawyers, and especially on the telephone. Never talk to a lawyer on the telephone. But anyway, this was outside his office, and I thought, all right. He said, "You've been quite a problem to us." And I said, "Well, I'm just trying to defend my own interests. I think that's my right." He said, "You're not going to be a problem much longer." And I said, "Well, why is that?" He said, "Well, the IRS is going to take care of you." So I looked at him and I said, "Well, I have no problem with the IRS." He says, "Well, you do now." So the next day I got a letter from the IRS calling me in for an audit. So I thought about it, and I thought, well, I'm a very nervous person, and this upset me a great deal and could cause a heart attack and so forth. So I immediately filed suit against the IRS agent for terrorism because I was terrified. Now, I really touched a nerve because I did not know at this time, but there have been quite a few people, elderly people, who have had heart attacks and died in IRS offices, which I knew nothing about at that time. So they had no intention of ever having this case heard. I filed it in state court because I wanted it to be a state matter. So they immediately remanded it to federal court. Well, I have my own set of the U.S. Code, so I opened it up, and there were hundreds of pages about cases where when it's gone to federal court, you can ask it to be remanded to state court. So there was lots of interesting stuff there. So I filed about a 40-page motion to remand to state court, which they refused to do. So then I filed 38 motions in that case, even though it never got to court. And I filed 5 motions to halt the collection of income taxes in the entire United States until we resolve these pressing matters. Because, I'm not a selfish person, and although I was concerned that they might be trying to collect too much money from me, why should I ignore all the other people out there? They're probably gouging them too. So the only sensible thing to do would be to halt the collection of taxes until we resolve these legal problems. And I found in the U.S. Code 2 areas, 2 citations, and it's in my book, A Writ for Martyrs. It's also in A Rape for Justice. 2 areas of the U.S. Code which allow for injunctions against the collection of taxes. And so everything that I did was absolutely legal by the U.S. Code. Well, those motions, none of them were ever heard, and they finally dismissed the case. So then the outcome of that was that after they dismissed my case against the IRS, the agent then filed a delinquency claim against me about 6 months later, because they had disallowed all of my deductions, and I have a lot of deductions because I'm a self-publisher and I usually publish at a loss. So I was now faced with a 90-day letter that you have to answer within 90 days or to get the lien against you. Now, a lot of people get indignant and they say this is such a criminal thing that I'm going to ignore it. So they sit back and they let the IRS get the lien against them. Then the IRS comes and they take their house and their car and their bank account. But I don't think you should sit still for that. I think you should attack right away. So I immediately filed to go into U.S. tax court. And my friend said, this is horrible, you should never go into tax court because the judges are former IRS tax agents and you haven't got a chance. Well, I had known all along you don't have any chance in any American court, so tax court is no worse than any other. But you see, most people still have the delusion that you can go into an American court and get some kind of fair hearing. This is absolutely not true. I have never obtained justice in any American court, and I don't think anybody in this room can. So what you have to do is go into the court with more ammunition than they've got. You've got to have everything when you go into court, and you've got to know what you're going to do, and you've got to be on the attack all the time. You cannot sit back and let them do things to you. You've got to do things to them. So I went into tax court despite the warnings of my friends that I was going to be massacred. And I thought, well, I don't want to go in without some preparatory strategy. So I filed several motions with the tax court, and one of them was a stipulation that the FBI and the IRS had conspired to have me put in a mental institution, which was true, and the details are in my book, A Writ for Martyrs. Even though they never succeeded in doing it, they definitely had the program, and I had 60 pages of memoranda from the FBI sustaining this. Most of my lawsuits, I prefer to use government documents because they cannot go into court and defend against a government document. I don't go in with my opinions. I don't say, I think this or I think that. You've got to have statutes, you've got to have government documents, and you've got to hit them with their own stuff, because most of the legal maneuvering is a charade anyway. And I discovered this quite by accident when I was working in Chicago a number of years ago. And at that time, the headlines in the paper every day were about the trial of the Chicago Seven. There were 7 communists who were accused of plotting to overthrow the government and so forth. And they developed a very unique defense. They went into court every day and made the entire court into a circus. And the judge did not know how to handle it. The lawyers didn't know how to handle it. And so I thought at that time, this was back in the early 50s, I said, boy, the way to handle any legal situation in court is to turn it into a circus. But you yourself cannot go in and be the clown. What you have to do is let the clowns come in and take over the whole situation, which is very easy to do if you start it in the right way. So that was the lesson that I learned many years ago, that to go into court, you're participating in a charade. The lawyers and the judges know what is going on, and in the adversary system, they are totally protected. Now, the adversary system is that 2 parties come into court to fight out an issue. It's sort of trial by combat, and usually the most powerful guy wins. That means the guy with the most money and the most influence. So there again, very few people understand this on the adversary system. They believe that the adversary system means both parties come in and they present their case, and then a decision is made by the judge or jury as to the relative worth of their cases. Well, that really has very little to do with it, because in many cases the judge has already made up his mind ahead of time, and anything that you say in court will have no effect whatsoever. Now, I even got that in The Rape of Justice. I quote a very revealing interview in the Harvard Law Review of 1987, page 787, in which Philip Elman, the law clerk for Supreme Court Justice Felix Frankfurter, during the hearing of Brown versus Board of Education before the Supreme Court, Philip Elman said, Thurgood Marshall could have stood up before the Supreme Court and recited, Mary had a little lamb, and the decision would have been the same, because the court had already made up its mind on the case. They didn't have to hear any of the argument because it was a foregone conclusion. So this is true in many cases, that the judges have made up their minds. And you're sitting there thinking, well, my lawyer is really making a good case. He's bringing in all of my evidence, and things are looking good. Well, that's simply not true, because I don't care what evidence you have in your favor, they are not going to, it's not going to affect the outcome. So as I say, I filed before the tax court a stipulation that the FBI and the IRS had been engaged in an illegal conspiracy against me. So when I went down to the tax court hearing in Richmond, I walked in and there was the meanest looking judge I've ever seen in my life. And so I sat there and my case was called Eustace Mullins versus Commissioner of Revenue Respondent. And I stood up and I said, Your Honor, I have this motion before the court, and I think that we should get right on that. So he looked at me and he said, Now, Mr. Mullins, this court has no time to hear that motion. And I couldn't believe what I was hearing because, you know, the courts have all the time in the world and all the money in the world because they just spent $14 million in California to decide whether some children had been molested in school, and the outcome was still in doubt. And they spent $40 million, the Department of Justice spent $40 million to find out whether Colonel Oliver North had paid for 2 tires out of his own pocket or not. The most expensive tires in American history. And so when this judge told me they didn't have the time to go into this, I knew the fix was in. So I wondered what they were going to do now. And I looked around, and there was nobody there from the IRS, which is very unusual in a tax court hearing. So the judge said to me, I want you and this, there was a young attorney there from the Department of Justice, a district attorney. He said, I want you and the district attorney to go into a room, and I want you to argue this out. So I went in with the guy, and he was very pleasant, and I presented some deductions and so forth. And I didn't have any substantiation for any of it, but I gave him some figures, and we argued back and forth for about an hour, and I could see that he really wasn't pushing at all. In other words, he was just making a token defense that we would go ahead and resolve this situation. So he finally agreed that I did not owe any money whatsoever, and we went back out to before the judge, and he said, Now, have you all resolved this? And the attorney said yes, and I said yes. So he gave me a letter, which I reproduced in the Writ for Martyrs, stating that I had no tax deficiency. And I have never heard from, that was in '82, and I've never heard from the IRS again to this day, which sort of annoys me because there are a lot of new things that I'd like to present in court. And I haven't had a chance to argue them. You know, you keep coming up with new things, and you think, boy, the next time I get into court, I am really going to find out if this is going to work or not. But as I say, I can't get in, and I don't have any lawsuit against anybody right now, which sort of leaves me at sea. But I'm hoping something will come up. Because if Judge Learned Hand may dread a lawsuit, but I don't dread them at all because I like to get back into the Corpus Juris Secundum, which is this enormous set of books which covers a whole wall, and it's just full of stuff. And the U.S. Code is also full of things, and you can go in the U.S. Code and pull out anything you want. It's really amazing. I mean, I don't care whether you're for something or against something. You can go in the U.S. Code and you can find a good argument either way. And the reason for that is that the legal system is mostly double talk anyway. And once you find this out, you just can go in and you can get the material and you can file these motions and you just keep rolling right along. Now, when I started going into the federal courts, they were building new ones, and the one in Charlottesville, Virginia, was absolutely palatial. It had huge chandeliers, it had carpets 1.5 feet thick, you know, and they had special stands built with the built-in microphones and all this for testimony. So I began to think that our courts were really palaces because they were so palatial. But after a lot of experience in the court and how the courts are run, I realized they're not palaces, they're actually temples. And they're temples of a religious system which we know nothing about, because they have not one but two secret legal codes which you American citizens are never informed about by the lawyers or the judges. Now, the first code is the Kabbalah itself, which is a mystical religious precept, and the code itself is based on this. Now, I discovered this quite by accident, because in my research for my book, I found I do what they call total research. I go back and I check every newspaper article, every magazine article, and every book on my subject. And I can do this because I learned when I did this research for the Federal Reserve book in 1948, and I had to go through 2,000 books to get that book. And I was faced with the entire journals of the American Economic Association, which were a set of about 40 books, so about 1,000 pages each. So I had to learn to go through thousands of pages very quickly. And I did learn to do that. And I think one of your speakers here has pointed out that you can develop this ability. What you do is you don't skim over, but you scan. You scan the pages very quickly with your eyes. I regularly go through about 10,000 pages a day in my research, which seems like an impossibility, but it's really no problem, because first you know what you're looking for and you focus on what you're looking for, and it's really not that difficult to do. So anyway, I picked up an article in the Columbia Law Review, June 1935, by a Dr. Felix Cohen, who had been a professor of law at Columbia University for many years. Now, Dr. Cohen said, "Due process of law is a metaphysical cover-up phrase. Legal concepts such as corporations or property rights are supernatural entities which do not have a verifiable existence except to the eyes of faith. Rules of law which refer to these legal concepts are theorems. Jurisprudence is a special branch of the science of transcendental nonsense." Now, this is a professor of law at Columbia said this. And so that is how I found out that there is a transcendental concept in our entire legal system, which goes back to the Kabbalah, and which is was described by another professor of law, Fred Rodell, at Yale University. He's written a very good book on the lawyers, by the way. He said that lawyers are purveyors of streamlined voodoo and chromium-plated theology. And he calls law a high-class racket. So you see, I'm quoting now from law professors themselves. And I think what it is that they become disappointed in their students, whom they have tried really to make into good lawyers, and they go out and they become racketeers. And so they're venting their frustration at the way these people turn out. So when the law professors themselves call this chromium-plated theology and transcendental nonsense, you can see that I am justified in saying that these secret codes are codes of the temple. Now, this goes even further. The judges refer to themselves as the cult of the robe. Now, the cult of the robe means that this is a 5,000-year-old cult, and they wear the black robe, which is the color of death. They do not wear the color white, which is the color of justice. Traditionally, in our culture and in all cultures, white has been the color of purity and of justice. So why is it that the judges do not wear white robes? Because they go back to the Babylonian cult of Baal 5,000 years ago, which is fully described in my book, The Curse of Canaan. And when you go into an American courtroom, you're going into a temple of voodoo, the cult of Baal, which was based upon child sacrifice and based upon sexual orgies, and this is the basis of our legal system. Now, the second secret code of our legal system is that you're under, you see, as American citizens, you believe that you are fully protected by constitutional law, which itself goes back. Blackstone says, law is from the Supreme Being impressed certain principles upon matter from which it can never depart and without which it would cease to be. Now, Blackstone described law then as, we know that today as DNA, that there are certain precepts impressed upon matter. Well, Blackstone knew this 300 years ago, and that's why he called law coming directly from God. And of course, all law should come directly from God, because then we can obey it. But if it's simply a man-made law for some man's purposes, then why should we obey that? So the Blackstone precept and the biblical law were finally incorporated in our Constitution, and we believe, and the Founding Fathers believed, they had set up a system where the American citizens would be protected in our courts. Well, this was gradually superseded by the law merchant or admiralty law, which brought us under the law of the Bank of England, not the throne of England, but the Bank of England. And that is all explained in my book, The Rape of Justice, also. So when you go into an American court, you are under martial law. The judge is the admiral. He has the power of life and death. He has the power to impose punitive actions against you. Whatever he wants to do, he can do under martial law. He cannot do it constitutionally, but he doesn't care about the Constitution, because the Constitution is not even present, and he has behind him the flag, the gold French flag, which is the Admiralty flag, and that gives him the authority to impose whatever punishments and whatever judgments he wants to impose against you. He can do it under the Admiralty precepts. Now, you can defend yourself against that by, when you go into court, you ask the court to state for the record, are you using Admiralty procedures? Is this an Admiralty court? No judge in this country will ever answer that question directly. They may say, well, that's not relevant, and so forth. Well, then you ask that the charge be read to you and explain which is your right under the Sixth Amendment of the Constitution. Now, I was told that a friend of mine in Wisconsin recently won a very good case. You know, many of you have been harassed by these cases because you are offering treatments or suggesting treatments of one kind or another. Well, this gentleman, Conrad LeBeau, they came after him. He had been selling hydrogen peroxide, and he'd been doing other things. And so they came after him, and he went in and argued the Ninth Amendment to the Constitution, that you have the right to seek any medical treatment that you like, and the court upheld him and dismissed the case against him. He won the case flat out on the Ninth Amendment. So you can, even though it's an Admiralty court, you can win on a constitutional pleading if you bring it in and hit them with it directly. And this is what Conrad LeBeau did, and I think that many of you who have been affected by this harassment by the FDA and by the hordes of federal agents, go right after them with one of the Bill of Rights, and you will be able to defend yourself successfully. And the thing, too, I do add that under our judicial system, no case in an American court ever can really be ended. You can keep it going as long as you want to. So if the decision is unfavorable, you simply keep it going a little longer, and sooner or later they'll get tired and come around to your side. So I hope that I've been of some help here, and I appreciate your listening. Thank you.
Now, wouldn't you like to have lunch, dinner, or breakfast with him? I think he's approachable, don't you? I know I do. If you've never been arrested You really haven't lived an eventful life. I was followed by 8 cars last summer, and they pulled up behind me when I pulled the turnaround in a parking lot, and screaming, yelling FBI agents came at me from all directions, cursing and swearing, and I tell you, they used the filthiest language you can imagine, and arrested me on a charge, and it's a long story, and I don't want to bore you with it, but anyway, it's quite an experience. And then they say that they'll take you downtown. That's what they do. It was a 5-year-old thing that they had decided to drum up against me, and we think, and we're still doing a lot of things like he's talking about, and now we got new things to throw at them and get them to consider. The reason is perhaps I'm active in conducting conferences such as this, which promote the area of freedom of choice in your health care or your legal care or whatever. We don't know the real reason behind it yet. We're trying to get freedom of information and that sort of thing. But Jerry Friedenstein, who you'll hear this afternoon, was he and I were trapped or entrapped in that same situation. And only they arrested him in Ohio and me in Colorado. And they had worked 4 or 5 years putting this thing together. And we think it's because the things that we do are injurious to the financial health of the drug companies, the other people that can reap great rewards from what they won't get if you people and if enough people learn about it, how to do without their drugs and their certain things. Now, we don't know this for sure, but we're trying to figure out and find out just why they spent so much time and money. He talked about money. They spent a bundle of money, a lot of hundreds of thousands of dollars, doing this against us. We may talk about it a little more later. But